I would like to request everyone to switch on their cameras. We will be starting in a couple of minutes. Good evening, everyone. I hope you all are doing well. On behalf of Legal Specs, I would like to extend a warm welcome to today's session. My name is Yoshita Manral, and I'll be your host for this insightful event. Legal Specs today stands as a trusted platform dedicated to shaping the careers of aspiring lawyers. Through precisely curated courses, workshops, and interactive sessions like today's, we have continuously empowered young professionals to excel in the legal field. We are excited to have you here and we look forward for a productive and engaging session. Legal Specs welcome all the participants and is thrilled to have you here today. We are here for an insightful sessions on Beyond the Courtroom, Thriving Careers in ADR. Alternative dispute resolution offers a dynamic avenue for lawyers seeking to explore opportunities beyond traditional litigation. With a growing emphasis on mediation, arbitration, and conciliation, ADR presents a wealth of career possibilities. For aspiring legal professionals, ADR means owning skills in dispute resolution, understanding international practices, and contributing to a more collaborative legal landscape. We look forward to diving deeper into this promising field today. Now, as we move into the core of today's session, it gives me immense pleasure to introduce our esteemed guest. Let us warmly welcome Mr. Param Bhamra, whose remarkable contribution to the field of ADR continue to inspire legal minds globally. Mr. Bhamra is a founding partner at MediateGuru, a global initiative with a presence in over 150 countries. His expertise in international arbitration and mediation has significantly contributed to bridging the gap between seasoned ADR professionals and aspiring practitioners. An accomplished author, Mr. Bhamra has written over a dozen books, including Mediation, Practices and Strategies in India, and Arbitrating the Atmosphere, focusing on ADR. His works are featured in renowned national and international journals. Mr. Bhamra is affiliated with esteemed bodies such as Chartered Institute of Arbitration, the Singapore International Arbitration Center, and the Mumbai Center for International Arbitration, underscoring his commitment to excellence in ADR. Additionally, he has mentored future legal professionals as a judge at prestigious ADR competitions such as the Middle East Moot and AIAC Moots. Today, we are privileged to have Mr. Param Bhamra share his wealth of knowledge and insights with us. Without further delay, let's welcome Mr. Bhamra to the session. Before we dive in, just a few housekeeping rules. Please ensure that your cameras are switched on throughout the session to maintain an interactive and engaging environment. Keep your microphones on mute to avoid any disruptions during the session. And if you have any questions, feel to drop them in the chat box. We will address them during the Q&A sessions at the end. It is our great pleasure to introduce Mr. Param Bhamra. The forum is yours, sir. Please.
Thank you so much. Good evening, everyone. I'm pleased and honored to be here. I would like to say thank you, Mr. Tripathi, for having me here, and Ms. Manral for giving me for such a vibrant introduction. That made me seem like an expert in the field, but trust me, in ADR, I would say it's all blind leading the blind scenario. But nevertheless, thank you so much for the introduction. And so today we are here to talk about ADR. Now, can I assume everyone here have the basic understanding of ADR, what ADR is? You can use chat box, you can turn on your mic. Just basic. Anyone else? No worries. Okay, some of you not. Praneet, I might want to disagree with you that it's just for the smaller disputes, but we'll get into that. So, ADR is basically alternative dispute resolution mechanisms. We will get into the career aspect in a bit, but let's just talk about ADR in general, what it is. In a long story short, it's basically out of court settlement. That's just what it is. Now, if you want to complicate matter further, we have few branches in ADR: arbitration, mediation, conciliation, negotiation, adjudication. Now, uh, does everyone here got all the 5 points? I'll repeat: arbitration, mediation, negotiation, conciliation, and adjudication. Now, for the today's lecture, we'll focus on arbitration and mediation because, well, I only have functional knowledge on both of these two, to be very frank. So first of all, the question arises that, as many of you have already mentioned, that ADR is a mechanism to resolve disputes out of court. That is true. ADR is basically a faster alternative, cheaper to be used as an air quotes, and efficient. It definitely is. But I would say the strongest suit of ADR is the confidential part, the confidentiality. As most of you would know, that all the ADR proceedings are confidential. Whereas if you go for a case or any dispute in a court, all your evidences, all your statements, all your confessions, whatever you do, it becomes part of public record. But whereas the same setup in an ADR proceeding, either it be arbitration or mediation or conciliation or whatever it may, it will always be confidential. It will always be inadmissible in court. So now I hope we know now about ADR. The people who said no, can you please let me know if you want me to go deeper into ADR? What is ADR? Okay, I can see one yes. Okay, perfect. So now the question is, why ADR? We have a perfectly good court system, justice system. Then why do we need an alternative mechanism to resolve disputes? Because, well, I said confidentiality and everything. But again, why? The point is, uh, we are entering into the golden era of ADR. Now, why do I say this? Now, if I can assume correctly that most of you here would be law students or lawyers, uh, then again, if I can make an assumption that most of you would have read the Bar Council of India's notification last year that BCI is now allowing entry of foreign firms and foreign legal practitioners to practice in India. Does anyone went through that notification? Kanishna, do you want to say something? So you have. Now, does then anyone else tell me that what does that notification talk about? That in which fields did they allow legal practitioners and law firms to practice in India? Can anyone tell me? Okay, I understand it's becoming more like a question and answer round where I am asking you questions. Never mind, I'll just answer it straight away. So, BCI has allowed entry of foreign law firms and foreign legal practitioners to work in two fields and only two fields. One field is of international law, second field is of arbitration. That clearly states the agenda of BCI to promote India as an arbitration hub across at least Southeast Asia. And because if you see today's business regime, most of India's high profile arbitration cases go to Singapore, to SIAC, that is Singapore International Arbitration Center, or either they go to DIAC, that is Dubai. So basically, Indian authorities want to make India as an arbitration hub and to keep most of those cases in India. and even to attract foreign customers or foreign businesses to come to India and resolve their disputes. And in furtherance of that, even our government is keep on amending Arbitration Act day and night. You can see there are over 7 amendments in last few years from 2015. There were a number of judgments which have made Arbitration Act more liberal and free from judicial intervention. So that is why I'm saying that we are entering into a golden era of arbitration as well as mediation. If you know, a mediation act has been passed by the parliament. There is a commercial courts act which made pre-litigation mediation a mandatory clause. So see, the point is disputes are not evil. The government wants the disputes to get over as soon as possible so that we can go back to business. Because if we go to court, let's take a hypothetical example. Let's say there's a dispute between two Indian companies. Let's say it's a dispute between Reliance and Tata. They'll go to court. You know, again, if you assume there's a dispute over some factory plant, Tata is saying that Reliance has copied one of their mechanism or the patent. They'll go to court. All the patented models which are currently in the factory or the market, they get a stay order. The matter will go on for years and years and years. Meanwhile, the factory or the manufacturing plant will stay closed. Their workers will not get salary. It can go on for 5 years, 10 years, God knows how long. Whereas, if the case were to go for mediation or arbitration, now the timelines are pretty much different, but it is believed that in an arbitration, the case can be resolved in an year or so, or maybe two. Whereas in mediation, it is believed that the case can be resolved within 6 months. Now, this is not a very straight formula which can be applicable on all the disputes, but I would say even if the dispute is resolved within 2 year framework, it is still way, way, way faster than 10 years or 15 years or however long that is. So everyone, even our government, is promoting ADR so that people can get rid of their disputes as soon as possible so that we can go back to business, so that our economy can get a huge boom. That is why ADR is being promoted and is currently being utilized by many people so that they can spend less money on lawyers and they can earn more in business rather than keeping their factories and plants shut down. It is efficient, it is time saving, it is cheap. Again, cheap, it depends, because if you go to high profile arbitrations, it will end up costing you more than the court system. Whereas if you go for mediation, it will definitely be cheaper than all the alternatives. Now there's an increasing demand for ADR. Can anyone tell me why and how? Now I told all this, efficient, confidential, but there's an increasing demand for ADR, especially arbitration. Can anyone guess why? Yes, it saves time. Anyone else? Okay, I'm still looking for the one answer. Yes, economic boom, definitely. But what else? Market driven, yes, definitely. So everyone here is a law student, right? Manageable, yes. Globalization, definitely. All are correct answers. Resolution, yes. That too. Overburden, yes. All correct. But see, at the end, we all are, or we all will be lawyers, and we all are suffering through law school and suffering through this field or career to earn money, right? I mean, there might be some saint souls out there who want to fight for people, but I can say that majority of the people, including myself, are not that good of a person, and we are in it for the money. And arbitration have a lot of scope for the financial aspect of lawyers or the arbitrators. And we'll come to that, the fees part, at the very end when we'll talk about the career options. But moving forward, someone mentioned globalization. So I'll tell you this story. Does everyone here know in 1991, India opened up its economy? You know that LPG reforms we learned when we were in school, that is liberalization, privatization, and globalization. Now we had to do that because, well, India's reserves were running empty. I hope everyone know that we were on a very bad financial condition back then in 1991. The government opted to open up our economy. Now they did open up the economy. Now how can the government fill their coffers? By US dollars. How will they get US dollars? When people invest in India. But India, even after 1991, we were not gaining that much traction in order to attain foreign investment. So then our Prime Minister, no, not our Prime Minister, our Finance Minister at that time, Mr. Manmohan Singh, our former Prime Minister, went to Geneva on a conference, Geneva conference, and he read about the UN Citral model law. He came to India and pushed our current Arbitration and Conciliation Act of 1996 in the Parliament, which was then passed. Now, why did he needed to do that? Because see, let's say I am a person based in Dubai. Now I want to invest, let's say, $1 million in India. Now there might be a risk because see, it's not my country. If I go out and invest and there is some sort of risk factor involved, what if I run into some problem going forward? What if I had some dispute with my suppliers or distributors or whatever in the host country? They'll file a dispute, and now, as per my thinking, the court system of India will favor their own citizen over me. So why should I invest in that country? Hence, the arbitration comes into picture. I hope you can get what I'm trying to say. If there are confusions, please let me know in the chat box. We went from basic to advanced pretty soon, I admit that. So the point is, with Arbitration and Conciliation Act, foreigners, investors got a promise that in case of a dispute, they can opt to have a neutral party as quote unquote judge or arbitrator on their matters which our Indian courts will respect and whose award will be treated as a judicial decree in our own country. So that was the entire point. And from 1926, we can see our economy started to heal, and with time, from 2014 even, Arbitration Act were regularly getting amended in order to close all the loopholes, even our judiciary, as I mentioned. System of Mr. Ali will get to this at the end of it. This is a very good question. So, as I was saying, that what was I saying? Yes, so with time, even our judiciary started uh, granting judgments which were favor of strengthening arbitration, and judicial intervention was getting less and less and more or less every day. So we get, and we are still reliant on arbitration for that matter. That the BCI notification I mentioned, the still ongoing amendments, that is vital for India to become a $5 trillion economy in future. Now I'm not going on with some party line, but this is just out of fiscal policy. It's going to work, and the only cause I support is the cause of ADR and its promotion. I hope you don't all mind that. So, as of now, any questions, or we can move forward with the career aspect? Okay. So, career, let's talk about mediation first. How to become a mediator? Does anyone have any idea how to be a mediator? Anna Pahel. Anna, please remind, we'll get to this in the question answer. These are good questions. Yeah, so see you too. Okay, so for mediation, anyone know how to be a mediator? Does anyone know what are the qualifications you need? Like, you are a law student, can you be a mediator? Let's say I am a law student, can I be a mediator? Okay, so see, the point is, I got confused. I asked, I guess, too many questions, and yes and no are now got me confused. So I'll just go out and answer it. So anyone can be a mediator. Let's say there's a fight between your mom and dad, which we all know happens quite a lot. So if you are trying to get them both to calm down and go to their respective rooms, congratulations, you are the mediator. Now anyone can be the mediator, anyone at all. There is no eligibility criteria. Shreya, I disagree of that as well. We'll come to that. Anyone can be a mediator, but the fact remains. So, as per Supreme Court's MCPC committee, you need at least 40 hours of mediation training and 10 mediation proceedings as a co-mediator. Now, let's say, uh, since I can see Yoshita on my screen, I'll use her as an example. I'm sorry, I hope you don't mind. So let's say that Yoshita is already a mediator, and now I just completed my 40-hour mediation training. Now I want to be mediator. So I'll reach out to Yoshita. I'll say, Yoshita ma'am, I want to be mediator. So as per Supreme Court criteria, I need to do 10 mediations. So I'll ask Yoshita ma'am that, ma'am, please can you make me a co-mediator for 10 hearings? And if she agrees, and I sit on at least 10 mediation proceedings as a co-mediator, then you can congratulate me because I will be a mediator. Now again, mediator and arbitrator is a subjective term. Alright? It's like a businessman. Now who is a businessman? Do you need a degree to be a businessman? Do you need education? Do you need training? No, you don't need anything. Same goes with arbitration and mediation. But first, let's only talk about mediation. Now, as I said, sorry, that you don't need any education or anything, but I would still very much prefer that you do 40-hour mediation trainings. Because see, the point is, at the end, mediators are appointed. Because let's assume if you have a dispute with someone, let's say your neighbor is not paying you rent and you want to file a case. Now you go to court and you need to appoint a lawyer. Now, which lawyer will you appoint? the lawyer who has no qualification whatsoever, or the lawyer who has some qualification? People in the chat box, please. Yeah, exactly. That's a very stupid question, but just to make it pretty obvious. So the thing is, technically, on paper, you don't need any qualification or any criteria. But in real life, if you are if you are a mediator, let's say, do you guys know these? Let's take the example of IAMC. IAMC is International Arbitration and Mediation Center. It's based in Hyderabad. All right. So what they do is they empanel people. Basically, they collect database of people who are mediators and who are arbitrators. It's like, to be very basic, it's like a shop where you can go and browse mediators and arbitrators. And if you have a dispute, you can go to them that yes, we have this dispute, we want to go into mediation. So they'll show you mediators to scroll from. It's like, it's like your Insta follow list. You can scroll through and select names, which people you want. I hope you all got the concept, what I'm talking about. So if there's a dispute, all these centers like IMC, CIAC, DIAC, MCIA, etc., etc., they all will send you a list of people who can be appointed as arbitrators or mediators. And along with that, they will have your CV. Meditation. I hope you mean mediation. I'll come to that. So, they will have your CV in the list. So, it's all about impression. If your CV is good enough, the parties will appoint you. If your CV is not good, they won't appoint you. It's like getting a job interview again and again and again and again. So you need to have a solid profile if you want to be appointed as a mediator. Now, in mediation, I can assume most of you are based in India itself. So let's talk about the money part. So for, let's say, small matters in private mediation, a mediator can up around 30,000 per case. Now small matters are plentiful in India, and you can get up to, if you are a good mediator and you have good numbers of experience, let's say 5 years, you can get up to 10 to 15 cases per month. And since Mediation Act has been now passed and Mediation Council of India has not even been formed yet, in the upcoming 5 years, I can predict a very huge boom, especially in commercial sectors. Right now, mediation is very much prevalent in matrimonial field. I hope most of you see mediation as something only happens in matrimonial field, but in upcoming 5 years, you can see mediation happening in almost all the commercial aspects as well. So it's going to be a huge thing in mediation. Coming to the arbitration. Arbitration, as I mentioned in well-targeted mediation, is anyone can be an arbitrator. Quite literally, anyone can be. But again, the reality is you need to have a very good CV. But the problem with arbitration in India is, can anyone guess what's the problem of arbitrators in India? Any guess at all? But the thing, India, jurisdiction will be India only, and no cases. The cases are plentiful. qualification, we have qualified, that's not an issue. Different levels of knowledge, and that's a good thing. The people have different levels of knowledge. That's diversity. Okay. So the problem is Shreya lack of infrastructure and school. Well, we already have an ODR system, and there are quite pretty good institutions in India. So I would disagree. No recognition, maybe. It is recognized as a degree of court. Delays, it's very fast. Okay. No, so I meant as an arbitrator. So let me tell you, in arbitration, what happens is if you go to an arbitration center and you see almost arbitration is like a playground of retired judges. Can anyone understand this? If you go to any arbitrator institute and you enter into the center, you see the list of hearing, you'll find all the former justices of high courts or supreme courts are the arbitrators. Because see, the point is, I can see Shreya in the chat. So Shreya, let me ask this directly to you. Let's say if you have a dispute with, let's say Yoshita here. Alright, so we have a hypothetical dispute between Shreya and Yoshita. So now they both want to do arbitration. Now on one side they have me, Param, as a potential arbitrator. On the other hand, they have former Chief Justice of India, CJI UU Lalit. So who will they appoint? People, can you make guesses? Ali, there can not be two arbitrators. But yeah, obviously they'll go with the justice. So that's the point. And these people charge very, very high fees. That makes arbitration more and more expensive. And now again, can you guess why would they go for CGI and not me? When that CGI will charge them more money than me? Any guesses? Not qualification. Experience doesn't matter because at the end they will get an award which will have the same judicial value. See, the point is, I'm very disheartened to think that you think that I don't have much knowledge about this. But kidding aside, the point is, let's assume that in this hypothetical case between Yoshita and Shreya, face value is that's the answer I was looking for. Again, between this Yoshita and Shreya, let's assume they appoint me as an arbitrator, and let's assume I gave the award in favor of Shreya. Now, obviously, Yoshita will go to set aside the order in a district court. Now, the judge sitting, is anyone's mic on? Okay. So, the judge sitting there in the district court will see the name of the arbitrator first of all. Now, he's not supposed to, but this is how life is. They will see that, oh, this award is passed by some random person named Param Bhamra, I don't know him. So maybe it would have some merit to it. That, let's start the proceeding. But now let's assume the same case and Yoshita and Shreya had appointed the CGI. Now the losing party will go to set aside. Then the judge sitting there in the district court will see that, oh, this award has been passed by former Chief Justice of India. So then he will think at least twice before setting aside that award. It's all about face value and about the influence. with former justices still wield over them. So, as coming back to the very basic point, anyone can be an arbitrator, but in India we have this problem that most people don't get appointments, at least not early in their career, to sit as an arbitrator. So, what can you do? If you want to be an arbitrator, what can you do? So, first, you can practice as a counsel. You can represent clients in arbitration proceeding. You can go into disputes team of law firms or chamber practice who do arbitrations, or you can reach out to arbitrators, either Indian or foreign. I'll tell you, my first arbitration happened because I had a network with an arbitrator based in Dubai. So I asked them if I can get an appointment. They said that there is one case being instituted by Dubai International Arbitration Center. It's going to be online. So I can apply to be a secretary, a tribunal secretary. A tribunal secretary is basically like a court clerk who keeps up with the case, handles all the documentation and all the clerical work. So basically, you get the first-hand experience about what's happening with the case. So if you want to be an arbitrator in your life, you can be a counsel, you can be a secretary, and the money part, what I was, money part in arbitration is quite good, especially if you work in an international arbitration field. Sometimes the arbitrators get up to 10% of the entire dispute value. Let's say two companies have a dispute of around $1 million. The arbitrator's fees will be around $100,000. So it's huge money wise, and you'll be quite surprised to know $1 million disputes are not that rare. It's pretty very common and quite abundant. What can we expect initially? See, Simran, as I was saying, initially you can be a tribunal secretary. I mean, they do make good. They make around 1.5% of the dispute amount. But if you compare that to INR, that is still very good. I remember when I got my first Dubai appointment, and when they asked me about what will my fees be, I was quite shocked, and I was like, "Oh, am I going to get paid for this?" I had no idea. I thought it's just sort of unpaid industry sort of work. But you do get paid if you're a tribunal secretary. Now, if you work in India and do become tribunal secretary for, let's say, judges, or because judges are the pretty common arbitrators in India, they will get you on your team and they can get you a salary, but they won't pay you that good of an amount. But it won't be bad, but it won't be that good. So it will depend upon you. So if you want to be again, to sum up, if you want to be an arbitrator, I would suggest go through the council way or the secretary way. Now there is a chance that if you network very good, then you can get your appointments within 5 years of your career, which is very rare, but it's not impossible. And I've already told you the money field is quite huge. And except for all this, and for both this field, there is one more career, that is you can be a teacher, a professor, a trainer. That's all pretty self-explanatory. So you know what you can do. Now I can recommend you some emerging fields because see, even in our legal field, the ADR field, it's the business rule still reigns supreme. That is, first come, first serve. I mean, first comers advantage, which you can get. Like, I have been to many colleges all across India and I asked them, what do you want to do after graduate? And almost 90% people say they want to go into IPR. Now, see, I don't have anything against the field. I used to love that field in my law school. But again, if everyone is doing in that field, if you go in that field as well, there's just too much competition for you. And I mean, I'm sure you can be the top 1% of the competition. But again, I won't recommend you going into a field which has too much competition in it. So, see, even every field has competition, even arbitration has a lot of competition, but we have some fields which have pretty less competition. In India, such fields are like investment arbitration. If you know what's an investment arbitration, it's when a foreign entity invests money in India, or Indian company invests money overseas. There's clauses of arbitration in it. So whenever people have to appoint arbitrators in those fields, in such niche fields, people often see that who has the expertise in that field. Now again, let's say if you want to appoint an arbitrator in, let's say, investment arbitration case. Let's say a UK-based company was building a dam in Himachal Pradesh, and they had some dispute regarding to the, I don't know, the cement quality of the dam. All right. So they have, either they can appoint a former justice of Supreme Court of India who has no idea whatsoever on investment disputes, on the quality of cement and how that's significant, or how to deal with international cases. But on the other hand, let's suppose there is Mr. Aditya Shaw here. He has expertise in investment arbitration. He has expertise in, he knows what's the difference between good cement and bad cement, and he can deal international cases. So even though Mr. Shaw is not former judge of Supreme Court of India, he might still get that appointment because of his qualifications. And these qualifications can only matter in niche areas in which the qualification reigns supreme than experience. Because if you go through random contractual or commercial disputes, see, every lawyer, even a first year law student, can help you on that. But if you go on a very specific area, that means your clientele might be less, but that would also mean your competition will be very, very less. One such more is energy arbitration. All these people dealing in energy, solar power, your oil and gas. Then there is construction arbitration. There is infrastructure arbitration. Now there are people working in this industry, but it's very, very, very less. Now there are industries which are not related to ADR, but again very niche areas like your fashion law, your aviation law industries, and your technology law, media law. There's very few competition in law if you know specifically where to go. Now people have often heard from people saying that there's too much competition in law. I mean, I agree. There's too much competition if you want to practice in bail matters. There's too much competition if you want to engage in matrimonial disputes or commercial disputes or tax law. But I would say that choose a field which is very, very unique, and you need to excel in that specific field. Don't, you know, be a don't be a lawyer which can work in any field. Just pick one field in which you can be a master. Now coming back to the ADR part, I told you about investment arbitration, energy arbitration, construction arbitration. So about mediation, as I already mentioned, that commercial court have included mediation as a pre-litigation mediation, and even lawyers are preferring mediation nowadays because earlier lawyers used to hate mediation because anyone can guess. Can anyone guess why these lawyers used to hate mediation? Any guesses? That's right, Shreya. So earlier this used to happen that parties used to go for mediation and the matter would get settled and lawyers would lose their, court fees, their parents' fees, their, whole retainer fees, and every sort of fees because the matter used to get settled as soon as possible. But now, BCI has allowed entry of lawyers in mediation as well. So even lawyers will get paid even if the matter goes for mediation. Now, that's not a evil thing or that's not a bad thing because earlier lawyers used to recommend to their parties not to go for mediation because in a mediation table a client is sitting alone with a third neutral party. Now a lawyer is sitting with the client in mediation table. See, who is a lawyer? Now, in order to resolve a dispute, I would very much want a neutral third party, but I would also want there to be a person who will take my side, who know what's right for me, what are my rights, and who is not neutral, who's taking my side over a other person. I hope you guys can relate to this. So people and even Shreya, can you just type it out? And so people now prefer mediation because both the lawyer will get the fees and the client will get the support of lawyer in their mediation proceeding. Earlier, lawyers used to deny mediation as an advice to their client because they were not present there themselves. They were not present there themselves during the proceeding. But now they are. So this way, even lawyers now are, if not encouraging mediation, not outright denying it. So we are going towards a positive direction. So as a lawyer, you too have a scope in mediation as well. And earlier it used to believe that mediators are sitting in courts to steal the bread from lawyers. But now it's said that mediators and lawyers are sharing that bread. And I just conclude with remarks from Justice Lalit itself from one of his conferences I attended. So he said that there's a secret 11th amendment, 11th commandment that says that the pie is big enough for everyone. The pie being the disputes and that we don't need to fight between ADR versus court system and the lawyers to determine the disputes, that if someone is in a dispute, the pie is big enough for everyone and everyone will get what they want at the end. With that, thank you so much for having me and I can answer questions now. Okay, I'll just read from the chat box how it goes.
Thank you so much, sir, for that insightful and thought provoking session. We now have some time for questions. I would like to request everyone to share their queries in the chat box so that sir can answer them one by one. Alternatively, if you would prefer, you can use the raise hand feature and we will unmute you so that you can ask your question directly.
Meanwhile, I'll just answer Mr. Ali's question. Some companies already mentioned same arbitrator and disputer. Mohammed Ali, I didn't understand your questions. Some companies already mentioned some arbitrator. I'm sorry, I didn't understand. Can you please rewrite it? Meanwhile, Shreya Agarwal, how can we say it's cost effective when the party will have to pay both lawyers? Shreya, cost effective is a thing, but if you go to court, there will be date after date and date after date, and the matter will go on for years on end. There can be hundreds of days, whereas in mediation, even you have to pay the mediator and the lawyer, but it will be still resolved very, very soon. So you will end up saving a ton of money. And I question difference between mediation and arbitration. Uh, Anna, I like to answer your questions with a bit of narrative. That is, and please don't quote me on this anywhere. So mediation is like a therapy. You know, a couple got into fight and they go to therapy. They'll talk about their issues and stuff with the mediator, and mediator will try to console them, and they reach an agreement. That's mediation for you. Whereas an arbitration is like a private court system. There is no difference whatsoever. There is supposed to be difference of procedural laws and everything, but as I mentioned that all the few former judges sit on arbitration benches, so the procedural laws, the CPC, the evidence, all are applicable. So that's the real life difference. But if you want a textbook difference, that is that mediation settlement agreements are enforceable only as a contractual agreement, whereas arbitrator gives a unilateral award, and their award is enforceable on both the parties, enforceable just like a decree of the court. I hope you get the point. Energy arbitration. Anmol, I don't really understand what you want me to talk about energy arbitration, but there are quite some disputes in the energy field as well. It can be as basic as quality about energy. Energy arbitration cases are just like oil disputes, gas, natural gas, CNG, petrol, or solar power, dam, any disputes you can imagine will come into energy arbitration. Can we challenge arbitration solution? Mr. Ali, you cannot challenge a solution because there is no solution. An arbitrator passes an award on the dispute, and once the award is passed, that award is treated just like a decree of the court. And if you are unhappy with the decree of the award, you can go to court to set aside the award. It won't be amended, it won't be modified to an extent, but it can be set aside if the court thinks it can be set aside. What is the disadvantages of ADR? I don't think I'm the right person to answer that, but if I have to say, I can't find any disadvantages about mediation. But for arbitration, I can say that it can be very, very, very expensive, and sometimes it can take a lot of time, maybe even more time than the court procedure itself, because first will constitute an arbitral tribunal, then the tribunal will deliver their award in a year, Then you'll go to district court to set aside the award. And then if you are unhappy with district court, then you go to high court, then you go to Supreme Court. Even then you'll file for a review petition and all that. So even some award that delayed for over 10 years. Now it's a very rare case, not always. Mr. Ansari, how do we ensure fairness in ADR? Well, at the end, see, it's the parties who get to decide, the arbitrator or the mediator, and so it's totally up to them to appoint a person who's fair and just. It's like if you are filing, let's say that if there's a dispute between Reliance and Tata, the parties cannot possibly appoint Mukesh Ambani as the arbitrator. I hope you get the point. So you always involve a third party, which no party will have a direct connection to. The third person who will not, benefit or get disadvantage from engaging the process. Tush Tarji, what motivated you to pursue your career in ADR? That's a funny story. At my time, there was no mediation law as well. So when I talked to my teachers about what field should I go to for criminal laws, I had to study IPC, CIPC, for civil, CPC, and all that. So then we went to ADR, and I got to know that I don't have to study anything whatsoever in order to go into ADR. Just Arbitration Act. So I was like, I can handle Arbitration Act. So I was just a lazy student back in my time, and that's how I ended up in ADR. The 10 RERA proceeding can be replaced by ADR. Mr. Jha, any proceeding except for criminals can be replaced by ADR, provided that they have clause in the contract from the very beginning. There cannot be any arbitration if there is arbitration, if the arbitration clause is absent from the contract. So in order for every arbitration to commence, there need to be an arbitration agreement which need to be put in place way before the dispute. It can't be put in after the dispute, but before. Shreya Agarwal, basically mediator. Shreya, absolutely right. Good job. Muhammad Ali, some companies already mentioned that if there is any dispute between parties, then they will prefer to go to ADR. Yes, Muhammad, you are right. As I mentioned, that most of the companies nowadays, whenever you sign a contract, there is already a clause present that they will go to arbitration or mediation rather than the court in order to save their time and money and just for the sake of confidentiality. Guru Singh, where to register as arbitrator. Mr. Singh, you don't register as an arbitrator, you get empaneled as a mediator. A panel basically means that, how to put it delicately, that you want to be listed on their website or on their organization as an arbitrator. They have quite strict guidelines. Like last week itself, I was seeing Delhi International Arbitration Center's guidelines. They had some part that you need to have at least 10 years of experience as an counsel in arbitration. You would need to submit your 3 years of ITR that need to be around over 8 lakh annual monthly issue, and then you need to submit few of the ADR awards which you have received. So it's quite complicated, but you can get it done once you're in the field. So don't submit it, because copyright issues can be done with ADR. They can be done with ADR, but as I said, if you have an arbitration clause, then only. or if the decision by arbitration disturbs the basic structure of constitution, then we go to High Court or Supreme Court. Mr. Ansari, arbitration decision cannot disturb the basic structure of constitution because only commercial matters can go to arbitration or civil and not constitutional, because you can never see a government engaged in a constitutional matter in an arbitration. It's just not possible. Simran Nota, but I have used stable income in ADR. Now, Simran, I'll tell you my example. In earlier years, I chose to be independent because I could not work under someone else. It's just something wrong with me. So, in a starting year or two, it's pretty hard. But once your client get to know you, you can get good enough arbitration cases. You can get empaneled as debt recovery counsel as well, because all these credit card defaults, loan defaults, they have an arbitration clause in it. And whoever will default, they'll have to go for arbitration. So those sort of cases are pretty easy to get, as per my understanding. The rest is up to your fate. And stable income also depends upon the city you are in. If you are in Delhi or Mumbai, I would say your chance of getting a stable income pretty good. If you are in tier 2 or tier 3 cities, you might want to move to Delhi or Mumbai. And that's my view. Can mediation and arbitration be combined? They most definitely can. In many arbitration cases, this happens when the parties talk to each other. They believe that they can now resolve the conflict with mediation rather than arbitration. So then parties ask the arbitrator for time for stay order on the proceeding itself. And since it's a party-driven process, arbitrator has to give out the stay order. So then parties can try out mediation, and it goes backward as well. If parties are in mediation and they don't see that mediation is working, they can opt to go for arbitration. Now, in some cases, this can be happen as well. That I hope you guys have gone in moot courts. So there are like 3 issues or 4 issues to be determined in moot court problems and whatever. So sometimes in real life disputes, there are some issues. The parties choose that let's do mediation on these 2 issues and let's do arbitration on those 2 issues. So that's totally how it goes. But arbitrators don't have police or any mechanism, just like court order police. Mr. Ali, arbitrators award has the same value as of a judicial decree. So you can take that award, go to a court, get a stamp that will have the same value as of a court, and then if other party is not agreeing with the decision, you can file for an execution proceedings, and the court will grant their power to do. They'll order police or any department or however the case goes. If there is specific forum for dispute, can we still go for? See, it's totally up to the parties' autonomy if they want to go for ADR or if they want to go to specific tribunal. Like you have NCLT, National Company Law Tribunal, but there are still some cases who go to ADR. So that again depends on the party autonomy. Are ADR decisions legally binding? Yes, they are. Mediation agreements which the parties reach are binding as a separate form of contract, as a legal contract, whereas, as I just said, arbitral awards have the same authority as of a court decree. What is the major difference between court and ADR process physically? Okay, there are a lot of differences physically. Rather than a court clerk, you will find a secretary. Rather than arbitrator, rather than a judge, you will find an arbitrator. As I already mentioned, technically, there is no need for procedural laws. There is no need for all the strict procedures to be followed on how to do everything, how to file a submission, what to do, how to do. But since we have all the former judges and with the institution trying to, there are so many rules now that it has become almost same as a court. That's why I said that arbitration is almost as same as court, but the only difference is in court you don't pay the judge, but in arbitration you are paying the fees of arbitrator. Infrastructure arbitration, I have doubt about RERA cases. Okay, what's your doubt, Mr. Anmol? Sit in, let you how to get internship under you. Anmol, you can send me an email. Hello, sir. Being a freshman to the law school. Anindita, please, wherever you get ADR as a subject, please don't bunk it that much and try to not sleep in the classes. It's an interesting field. This advice goes for everyone. Try to attend as many conferences as you can. Now, the conferences, I don't mean the academic conference in which you have to go out and present a paper. I mean, if you want to do that, that's totally up to you. But I'm talking about the legal professional conferences in which there are panel discussions, the seminars in which legal luminaries show up, all the big people come to go there, listen to them, listen to their experience, try to meet with them, try to stay connected with them, try to become their friend. You should have friends in high places, because all that what we say is, do you know who my father is? That's again nothing but a networking thing, because you are saying that you know that influential person. So how can you know an influential person if you go out, meet with them, talk to them, make a profile on LinkedIn if you don't already have, connect with like-minded people there. If you want to be in arbitration, send request to everyone who was in arbitration. If you want to be in mediation, send request to everyone in mediation. Get to know who are the influential people in the field, who are the legal stalwarts, which judges of your High Court or Supreme Court take matters in arbitration or mediation. Get as much knowledge as you can. Okay. Intern. Oh, that's very nice. Again, you can write a mail to me. What is the legal value of award? I have answered that. Internship and answer that. What are the some strategies for breaking deadlock during negotiation? See, as I said very, very early, right after the introduction, is that I do not claim to be an expert or even anything in negotiation. So my advice can not be trusted upon in this. But personally, what has helped me is to be just listen to the party and see and try to understand what their problems are, and what's stopping them from coming to the middle point, and see if you have wiggle room, and if nothing else all works. At the end, you have to see that you are there to represent your client, and your client's interest should not be hampered because of other parties resisting. So, just in order to reach a settlement, never agree on a decision which is harmful for your client. Again, it might not help with your question. Again, I'm not the right person for this. I'm very sorry. Sir, can we go for arbitration for the part of the dispute, or should we go? Again, Ratnakara, that's totally up to you. Even in some contracts, I have read this part. There was a company I was advising in Qatar. It was a gaming company. So they had this clause in their contract with the developers of the game. The contract says that they will go to arbitration for any case which monetary value lies under $100,000. If the dispute value exceeds $100,000, they'll go to court system. So many people do that. That if there's this dispute, we'll go for arbitration. If there's that dispute, we will not go for arbitration. That's totally up to the party. Can ADR issue any warrant against any party? Again, that depends if other party is not agreeing on something, and then an execution proceeding starts in court, and the summons are sent, and other party is just not showing up after continuous summons. Then the court may direct warrant against other party, but mostly they'll just attack their property rather than issue warrants. Again, it's totally based upon case-to-case basis. Okay, one more idea. Okay, I think I'm done with all the questions. I'll drop my email ID and my LinkedIn profile in the chat box. So if you have any much further questions or any queries as such, I would love to chat with you all. Thank you so much, everyone. It was lovely talking to you all.
Thank you so much, sir. On behalf of everyone here and Legal Specs, I want to express our deepest gratitude to you. Taking time to share your valuable knowledge with us today. Your expertise on ADR was truly inspiring, and we appreciate how you highlighted the various opportunities in this field. Thank you again, sir. We hope to see you at future sessions. To all participants, thanks for joining us today. We hope you found the session as insightful as we did. Additionally, I would like to inform all participants that a feedback form has been shared in the chat box, which will last for only 15 minutes. Kindly ensure that you fill the form to receive your e-certificate. Stay connected with Legal Specs for more learning lessons and courses. We have provided all the links of the platform. Stay safe and have a wonderful day.
Thank you so much, guys. It was lovely seeing you all.
You are now free to leave. Thank you, everyone. Thank you so much, sir.
Thank you, ma'am.